Okay. All right. I can tell this is working. It actually seems quite loud. So I promise I won't yell or do anything shrill. Okay. So, hi, everybody. I'm Anna Manley. I tried to remember the first year that I was here. I think it was 2015. Sounds about right? Okay. So I just want to start by saying this is completely unrelated to my talk, but the first year I was here, I had the bathroom all to myself, and it was great. This year I went in, I actually had to wait for a stall, so that's actually kind of great, and I'm very excited about that. So congratulations to the organizers of this event. You've managed to fill the women's washroom at a security conference. That is, yes, that's absolutely amazing, so good for you. Yeah. No? But I will require a private bathroom next time I come back, just so you know. Okay, so this talk is I also need to start by saying I'm going to give you a few disclaimers here, not aside from my usual lawyer disclaimers. So when I put this abstract in for this talk, I thought that it would be easy, and that was incredibly foolish of me. There's actually books written on this topic, so what I have attempted to do is I've attempted to give kind of a general overview of the state of the law in this area. I've attempted to make you extremely paranoid about the activities that you partake in and undertake, but I've also tried to give you basically a working level of knowledge of this area and what happens when you voluntarily take it upon yourself to discover and then disclose security vulnerabilities to third parties. Okay, that's what I'm talking about. But so with that being said, this is a very cursory talk, although I will be drilling into some of the details. So I'm a lawyer. None of this is legal advice, all that stuff. This is my usual disclaimer. My answer to 90% of your questions is going to be, it depends. And that's incredibly annoying, I know that, but it really does depend on the particulars of a legal situation. But this talk was also, and the title of this talk was just an excuse for me to see how many cat pictures I could insert into a single presentation. I'm attempting to break my own record. I don't know what that is, but I think I've broken it with this slide alone, so spoiler alert, I was successful. So the reason I wanted to do this talk is that last year, around this time, a young man, we already talked about him this morning, which is good. He's 19 years old. He was arrested, and in what was reported to be a very spectacular raid, there were reports of his floorboards being torn up to find offending computers. I'm not sure if that's true, but that truth or lie has entered the zeitgeist, so it's part of the story now. And he faced prison time for unauthorized use of a computer when he downloaded approximately 7,000 documents from the province's Freedom of Information and Protection of Privacy website using their request portal, their client portal. So what actually happened is he changed the end of a URL and ended up having access to private information of other users of the portal, information that he shouldn't have had access to. And he downloaded all of the information because, why not? And he got himself into a lot of trouble. So this stock image is horrible. I'm sorry. I promise I'm not going to use it, but it's relevant. So the reactions ranged from poor kid to underdog hero type rhetoric for this guy. It's kind of this story of the big mean state coming after a curious kid with some computer skills, at least in this community. And I started to call him the W-Get Kid. I don't know if anyone else calls him that. That's how I refer to him. It's vaguely superhero-ish. I guess that exposes how I felt about the whole situation. But I called him this in spite of the fact that he was not a kid, right? He was 19 years old. And he wasn't really a hero. He was just a curious kid who screwed up, and to be quite frank with you, pissed the wrong people off. But as we talked about this morning, the Halifax police did eventually drop the charges against this guy. And I think that all of you breathed a collective sigh of relief for your teenage selves, because you had all probably done something at least kind of similar in the past. I'm not looking at anybody in particular. All right? But this incident was very important because it taught us something about how organizations respond to not only breaches, but also disclosure of security vulnerabilities. It taught us a lot about the visceral reaction that they have. Not only is it extreme, it's also very swift. And I'm not just referring to law enforcement. This was the Nova Scotia government basically saying, this is happening and we think we're being hacked and somebody save the children and oh my God, everybody's going to die, right? So the emotional reaction actually does make sense because if you think about the nature of the information that was on this portal, this is information that is intensely personal. Okay, and it was for the Freedom of Information request, so it wasn't one particular type of information. This was basically all types of information that the government had about people. So it could have been intensely personal information, and much of it likely was. Which is why the government, and many organizations have this type of information, which is why many of them freak out. Most organizations have some kind of intensely personal information because that includes financial data, right? So that's kind of, I'm not saying it was justified, I'm saying I understand their emotional reaction. So, but this is also why they're so quick to conflate innocent discovery with nefarious purpose, because they're not quite sure how to draw a line between the two of them. They're not quite sure how to do the distinction. But there was a lot of speculation here last year about this kid's motivations. However, it seemed to most outside observers that it was just a see how deep the rabbit hole goes type of situation, or like this type of situation. If you give a mouse a cookie, it's a children's book. Or this type of sweater pulling related situation, and whoever gets this reference wins. So I wasn't surprised by the story in the least, okay? I've represented companies who have experienced breaches, and the initial calls when they come in are panicked. They are very intense conversations, and people do get very up in arms about having somebody tell them that they have a security vulnerability. Now, I have the pleasure of knowing many of you, and my spouse himself is a self-proclaimed wizard of some kind. So I know that you're very curious people. I know that, and that's to your collective credit. That is consistent across the entire industry. That everybody in this industry is generally a very curious person, and I know that you have a cat and mouse mentality, and there's nothing wrong with that. But think of the language that you use to describe. Like your glossary, right? Honeypot, phishing, breach, brute force, Trojan horse. These are the languages of war and games, right? So, and it's very playful, but the playfulness and curiosity that you have that's necessary in the industry can get you into a lot of trouble, and trouble with the law. All right, and that's what I want to talk to you about. I don't want to necessarily harp on the W-Get kid and the right and wrong and the ethics of it. I really just want to talk about, on a practical level, when you disclose vulnerabilities as a volunteer, right, without permission maybe, what happens? So I've spoken about this section of the criminal code before. It used to have a different number. It used to be 341.1. It has since changed since I was here. So this is the anti-hacking provision of the criminal code, all right? Don't read it, it's boring. But basically what it is that if you fraudulently or without color of right, either intercept any function of a computer system, obtain a computer service, or use a computer system with the intent to obtain or intercept a computer service, or if you use a password or traffic in a password, obviously without the right to have that password, then you're caught by this provision of the criminal code. So it really does, if you think about it, it really does cover the majority of the activities that are the nefarious hacking activities. All right. Now the last section, or the kind of, I think it's number C, subsection C, refers to mischief. So any hacking where your goal is mischief has you caught by section 430 of the criminal code, and there's actually a specific section that deals with mischief in relation to computer data. This one is if you willfully destroy or alter data, or if you render data meaningless, useless, or ineffective, or if you interfere with lawful access or use of a system, then you are in breach of this mischief provision. So you are causing mischief. I know that sounds fun, but it's actually pretty bad. So this one is, like I said, it's specific to computer data. You can also be found guilty under the general mischief provisions, but this one is all about people who make data, like denial of service attacks, right? So, and also people who make data unintelligible. So mischief over $5,000, so where the damage that you've caused by way of your mischief is over $5,000, carries a maximum penalty of 10 years. And if the mischief causes an actual danger to life, not if it causes harm, if it causes an actual danger to life, the maximum punishment is life imprisonment. So that's pretty serious, pretty damn serious for hacking. Now, I guess in order to understand these laws, you need to understand the state of the law before they came into effect and what hole these laws were filling, what gap they were filling. So this case, the Crown v. Marr, I think I'm saying that right, it happened in 2015. It was decided in 2015, but the offenses actually took place earlier than that. So this was a situation where a gentleman with some knowledge of computers told his girlfriend that he would fix her computer, and he decided that he would extract the sexy pictures of her off of that computer and save them onto his computer. And then they broke up. You know what happens. He decided to distribute these images not only at her workplace, but also post them online on various sites. So, and she called the cops, all right? So then there's this court case. And one of the questions that arose at the hearing and trial was whether or not he had stolen her data, whether or not he had actually taken something from her. So this is more the theft. And unfortunately at the time, the only law that would have protected her from that theft of data, basically the only hacking-like provision at the time was for theft. But the court held in this case that he couldn't be found guilty of taking her data because data wasn't capable of being stolen. It wasn't something that could be taken. Okay? Now, this is why, and this is where the laws came from. This is why the laws have to exist, why hacking legislation came in. Part of the reason, and these cases, this is just an example. This is just the first one that came up on my search. The rest of them, there's a huge long list of basically the exact same scenario happening and courts not being able to grapple with the fact that someone has stolen data from somebody else using the traditional law at the time. So the law that applies to a vase or a car couldn't apply to data. That's why the laws came in. So the new laws on computer data didn't apply to this case because of the time of the offense. The new laws came in 2015. They got royal assent at that time. And this one obviously didn't apply. They dealt with that at the hearing. This guy basically got off scot-free. And as a side note, the laws regarding the distribution of intimate images without somebody's consent also did not apply to this case because they were not in force at the time. So this guy just got off scot-free. So you can imagine why would we want to create laws to protect people from these scenarios. And public sentiment has since changed. So the state of the law in Canada right now, and this is just me kind of summarizing the slides we've just gone over, is if you hack into someone's computer without their permission, even if their system is horribly insecure, even if they deserve it because they should know better, even if they have a duty to secure that network and protect people's data, if you hack into it, even to show the vulnerability, you're breaking the law. All right? This headline kills me, and the internet is just an absolute ridiculous place. So, but the point is that hacking is being taken very seriously now. It's an evolution where we came from the law, old laws trying to grapple with this new emerging issue. Laws now apply to that issue because public sentiment has changed based on the offensiveness of those previous cases. So public sentiment now is holding that hacking is very serious. We're all very concerned about it. You see news reports about it, various breach reports and all these things, and everybody is getting very up in arms and very paranoid about it. And this may sound very extreme, and I know that some of you have probably experienced this in some way or another, but I mean, consider this. So the last time I was here, I was quite pregnant. I was very round. I kind of waddled around. I didn't get to drink at the after party. It was horrible. But I'd since given birth to this. I'm kidding. He's actually way worse than that. No, I love him. He's fantastic. But when I was giving birth, I opted for the epidural. Okay, and I saw one of these wonderful, glorious beeping machines next to me. So I was hooked up to a drug infusion pump. That's what this is. Now, an epidural is generally a fentanyl drip. Not many people know that. Fentanyl is a very potent and dangerous drug. It's also glorious in that scenario. But the interesting thing is that this drug was locked up. It was locked up and it was followed around by nurses and there was like a chain of custody for the fentanyl, but the device was left completely unlocked, right? This is a locking, there's a plexiglass locking case around it. The device was left completely unlocked and it has an open interface. The model that was next to me had a handy little USB port on the outside of it. There have been multiple researchers who have gone in and have discovered that these devices have significant vulnerabilities. I'm sure that you're all aware of that. And my spouse, who knows a lot about these things, and I can talk about him because he's not here this time, so I feel like I can like bad talking while he's not here to defend himself. But he knows about these things, and he felt it was a very good time to talk to my anesthetist about device security. Yeah. The nurses were not impressed with him. So, but, and this is, let me get to my point. Under the current provisions of the criminal code, if you attempt to expose a vulnerability in a device like this, if you do so without permission, then you are potentially causing harm to a person. There's a risk that you are causing harm. You're causing genuine risk to life. Think about it, if some of the safeguards didn't work, okay, and the drip started running faster, I would be dead, okay? I would die from a fentanyl overdose directly to your spine. So there's a real risk here. And this is one of the things that when the public hears about this, they freak out. And they feel very vulnerable. And I know everything has come full circle. So I've talked about the Ashley Madison hack before. I talked about the legal implications of it in some of my previous talks at this conference. And so causing direct harm in terms of what happens when you break into a system or when you hack into a system, wasn't cutting it. That's basically why the laws changed. Okay, the law needed to catch up with the fact that simply accessing and disseminating information was a violation, and it eventually did. That's why the changes happened. So and part of that was from the Ashley Madison hack because we realized that people are actually deeply affected by their information being released. 2 people committed suicide. 2 Canadians committed suicide after the Ashley Madison information was released. You can imagine why. This was an adult website where people would attempt to find other people to have affairs. Of course, it ended up that only 10% of the people on the site were actually women. But the point is that there is a real risk. Now, after this happened and they started trying to find the people who perpetrated this attack, the Toronto police said specifically, this is a crime, we're coming after you, it's very serious. And that was, to their credit, one of the first times that they had actually come out and said, yes, hacking is a crime, it's very serious, it causes harm to people, we are coming after you. Now, unfortunately, the practicality of finding these people proved to be more difficult than they had imagined, I think. And no charges have even been laid in this attack. Now, other jurisdictions are also, who's heard of this one? This was another teenager with not for like brains, but no common sense, this type of situation. So this was an Australian teenager who hacked into Apple. Okay, they hacked into their mainframe between 2015 and 2017. He downloaded like 90 gigabytes of data, and he stored it on his personal computer. So I don't actually think he thought he was doing something wrong. If he thought he was doing something wrong, he would have done something else with the information and put it somewhere else. And he named the folder Hacky Hack Hack. So I mean, he wasn't exactly covering his trail very well. So he was caught, and he actually ended up pleading guilty. And because he was a minor, and because they didn't perceive any actual harm arising out of the release of the information, I think he received 8 months of probation or something like that, probably community service, which I'm sure for a teenager is worse than jail. But anyway, it didn't end up so badly for him, but the point is that it definitely could have. Because a lot of this and a lot of our perception of the reaction to these events depends on what actually happens. So if someone actually gets harmed by the event, then the response is going to be swift and it's going to be brutal. Whereas on the other side of it, if it's just a release of information, maybe it's not all that personal, even if it is that personal, if nothing bad happens, then the response is generally, oh, those hackers, and no one really pursues it. And that's partly because it's so difficult to pursue these criminal cases and a lot of police departments just don't have the resources to do that, and we talked about that a little bit this morning. Which brings me to, the obvious conclusion, hacking is really illegal. This is just, it's just illegal. But we're talking about something else other than hacking today. We're talking about you discovering a vulnerability and disclosing it. And that's where we need to really drill into the provisions and how you actually get caught by these provisions. And not how you can get out of them, because I can't advise you on how to get out of breaking the law and how to get off scot-free. But there are two elements to every crime, okay? There's the intent element, and there's the actual doing of the crime, okay? Your mens rea, which is your intent, okay? And the actus reus, which is Latin for, doing stuff. And it's the difference between just thinking about doing something and actually doing it, and it's the difference between accidentally doing something illegal, okay, and intending to do something illegal. And you need to know that ignorance of the law is not an excuse, okay? That's one of my favorite legal principles to tell people. Just because you don't know what the law is and just because you don't know that it's a bad thing doesn't mean that it's not going to catch you. So that's not what I'm talking about here. I'm talking about actually having to form the intent to do something, and that is an element of a criminal offense. If that's not there, if the intent isn't there, then you can't be caught by whatever the criminal provision is. Okay, and the classic example is breaking into a car. Okay, so we've got my little thought bubble, guy thinking about it, intending to do it, and the difference between him actually doing it. So this is an important distinction when we talk about the WGET kid, okay? He accessed information that didn't belong to him, that he shouldn't have had access to, but did his activities, did his actions rise to the level of criminal activity? And short answer, no. The intent element of the anti-hacking provision of the criminal code is fraudulently and without color of right. It's that one up on the top there. And fraud is exactly what you think it is, okay? So it's a deliberate deceit or falsehood. And color of right is something that's a little bit more obscure, but it's basically having an honest belief that you have the right to, in this case, access or use a computer or a computer system. Even if there's no basis in law for that honest belief, you have to, it counts, basically. Now, that's kind of it's a difficult concept to work your way around. There are multiple cases on people. There is a case actually where a woman murdered somebody in her garden. I think it was a relative of hers. She bludgeoned them to death because she thought that they were killing her infant. They were kind of hunched over. She came in and they were kind of hunched over the infant, and she hit them with a shovel or something. They died immediately. And she actually was not found guilty because she didn't have the intent to kill someone. What she had the intent to do was to defend her child. So she couldn't be found guilty of murder because she didn't have the intent to do that. So that's how powerful the distinction is, and that's how powerful the actual intent element of an offense is. But it does not include a mere belief in a moral entitlement to something. So I can't say, well, that's mine, so even though you think it's yours, it's mine, so I'm not stealing it when I take it from you. That's not how this works. It has to be, and in this context, just because you think they have a security vulnerability, I found it, therefore I can take advantage of it because stupid them. That's not how it works. So moral entitlement doesn't get you there. And the action elements of this offense are in A, B, C, and D. All right? We don't need to talk about those right now. We've already reviewed those. So let's take a look at this in the context of the WGET kid. All right? So did he obtain a computer service? He did, right? Okay? the computer system was a data store and client portal. Okay, he accessed it. When he accessed the stored information, he obtained the service. And obviously all of this is up for debate. This is only my interpretation of what happened. Did he intercept any function of a computer system? Well, yeah, he did. It was a storage system. He accessed the stored data. He intercepted that function. That's more, although that second one, I've given some thought to that, and I'm not so sure about that anymore. So if someone wants to enlighten me on that point, and maybe we can debate it later. But he also arguably used a computer system to obtain or intercept. So once he realized that he could access the information, he continued to do that and to download it. So he had the action of getting that information, but he also had the intent of getting the information. So certain elements of it are there. But this wasn't related to passwords, so we'll just kind of leave that off to the side. But he did technically have access to the system, as far as my understanding of how it went. So, but then the question is, was it fraudulent or was it without color of right? And that's where, in my opinion, this whole thing becomes really murky. Okay, and I don't think that it was, because remember that fraud is a deliberate falsehood. He changed the end of a URL to access the information. It wasn't that much of a change, and then all of a sudden he realized that he had the information. He thought that he had legitimate access to the information, right? So he just assumed. And the same argument goes for the color of right issue here, the color of right element. So he had an honest belief that he had the right to use the computer system, and just because he poked around and discovered that he could access other elements of the system doesn't mean that he didn't have color of right. But that is significantly more complicated, and I think that that's a really slippery one. And part of me doesn't like the argument that I'm making right now. But the point is that it's not obvious that he didn't have color of right, that he makes out that element of the offense. So, I mean, so was he reckless? Was he reckless in continuing to access the data? He absolutely was. Okay, I'm not gonna, I mean, he was a teenager, he's crazy. Should he have kept unraveling the thread? Probably not. He probably should have stopped tugging at the sweater. But his actions, in my opinion, fell short of a criminal offense. And it was obvious to me at that time, and I hoped and knew that the charges would be dropped basically because he hadn't made out those elements of the offense. And I think I spoke with a few of you at the time that I was pretty sure that it was all going to be okay for that poor kid. So this is a graphical representation of what actually happened, in my opinion, to the poor kid. Yes, I'm racking up the cat pictures. So honestly though, the whole story made me really sad. It made me very sad because he's a young guy. I mean, obviously he's technically an adult, but I mean, were you an adult when you were 19? I wasn't an adult when I was 19. I don't even know what I was doing. Probably getting tribal tattoos or something ridiculous like that. But it made me sad because he's a young kid, and he's got enough knowledge of computers to realize that this vulnerability is there. So he's probably a pretty smart kid. He has some skills. And he used those skills. His natural curiosity overtook him, and he did something that was ill-advised. And obviously hindsight is 20/20. But, I mean, I hope, what happened is that he did this seemingly innocent activity, and then he had the whole weight of the state coming down on him. His home was searched. He was charged with a criminal offense. The charges were dropped, but he still had that prospect standing in front of him. He would have been advised by whoever his lawyer was, okay, it was not me, that he had the potential for jail time, for prison time, okay? That's scary. That's scary for anybody, let alone a 19-year-old kid. And I hope that he has enough self-esteem or teenage ego to get over this event and to keep doing, well, the legitimate part of the work that he's obviously got some skill for. So I hope he touches a computer again. But the sad part about this is that it's enough to scare somebody away from the curiosity that makes them so good at this. And that's why I found it sad. So that's the criminal side of things. And the reason I like to deal with that first is because the criminal elements of these offenses and the criminal elements of hacking and how that relates to what you guys do on a daily basis is important because it informs the civil side of this issue, okay, of vulnerability disclosure. So let's talk about the civil liability. So the general principle is that if you're a manufacturer, you are liable for any issues with your product. We're not going to talk about that in detail today. I just wanted to put that general assumption out there because I wanted to say that it's actually more complicated in relation to software. The law is still kind of figuring out how we deal with manufacturer liability in relation to products. Is it direct? It's not like making a car. Cars don't, at least until very recently, cars don't interface with other software. And they're kind of just a one-off thing. Whereas if you manufacture a software product, it may interact with multiple other software products, right? So it's significantly more complicated. That's just one example. So we don't quite know how manufacturers' liability works. I mean, we have some cases, and the law has been working on it, but for the most part, it's still kind of the Wild West relative to more established legal concepts. But what that means is that manufacturers feel pretty vulnerable about their security deficiencies. So if these are discovered, and this is just another reason why they overreact and freak out, because they don't quite know how these vulnerabilities will be handled. They don't know the law. They haven't received legal advice on this. And to be honest with you, if someone came to me and said, hey, look, this person came to us, they've reported we have a security vulnerability, what do we do? I would have to do some research in order to fully answer their question. And I practice in this area. Okay, so it really is, it's more complicated than people think. So you all know the situation, okay? You're reporting to either a manufacturer or an organization that there's a security vulnerability. You find something, whether you went looking for it or not, you found it. And now how do you deal with it? And so when it comes to disclosure or dissemination of security vulnerabilities, you have two basic options. You have the in-house option, where you go directly to the company and you deal with it privately. And then you have the public option, where you deal with this by disseminating the information broadly on forums, YouTube proof of concept videos, and places like this, to be honest with you. Now, these aren't mutually exclusive. Some people do both. You know this. I don't need to tell you this. But when you do something publicly, the implications are a little bit different. And I can't really talk about that right now in detail, because that was the part of the presentation that when I started looking into it, I was like, holy crap, this is very complicated. And it's a multifaceted issue. You're engaging issues of freedom of speech, you're engaging issues of copyright, defamation, and all these things. So what I want to address specifically, just so that we don't end up having a conversation about broad strokes of nothing, I want to deal specifically with the private disclosure, okay? And what happens when you disclose them to a company. So choosing between the options is difficult, because there's no so-called ethical tradition for hackers. I know that some of you have your own ethical codes, but relative to other professions, you actually are somewhat ad hoc. And that's kind of frightening if you think about it, because you discover something, you feel you have an obligation to disclose it. There are courses that you have taken, certifications that you have that tell you how you should handle these things, but you don't have strict codes of conduct. You may have a code of conduct with your employer, you may have internal office policies, but, and I don't want to overuse this term, but it's kind of the Wild West for you guys as well, because there isn't a whole lot of actual strict requirements for how to handle these situations, and that's where people get into trouble. So, and what happens in these situations is, because you guys don't have any clear code of conduct, then when these incidents occur, you disclose a vulnerability, people don't know how to react. And when people don't know how to react, and they don't have a strict, okay, we do A, B, and C, then what they do is they go to a legal remedy, okay? They go to their nasty letters. They go to their cease and desists, specifically because they don't know what to do. So they feel vulnerable, they go to their lawyer. Their lawyer writes a nastygram. That's how it goes. When people don't have a remedy to solve it themselves, the law is supposed to handle that. That's what the law does. But law is a really crappy mechanism for handling these types of things. It is slow, it is slow to adapt, and it is, to be honest with you, really, really bad at adapting. It's just bad at it. So I'm going to go back to 2011. Okay, this was a situation. So first, State Super is a superannuation firm, okay, a financial firm. What happened was a person discovered that you could see other people's information just by changing a URL once you were logged into the system. Sounds familiar, right? I know, it's almost like this is a common thing that's been known for some time, and yet these issues keep arising. And they sent this person who discovered and disclosed the vulnerability to them an angry letter. Don't read that. Don't read it. I'll read it for you. Okay? So to summarize, there were various threats in the letter. Okay? There were criminal threats. So we're going to report you. This is American, so the clauses are different. I know you're all reading it. I know you're trying to read it. So you just want to see how lawyers engage with each other. We're weird. So it's a jail, okay, prison, threatened, and civil suits, okay? And they said, look, we're going to make you pay for all of our legal fees in relation to this, and we want your computer, and no more access for you. You're not accessing our system anymore. You've breached our terms of service by even reporting this thing to us, by exposing this vulnerability, and we're really, really mad, basically is what happened. So the person received this letter in spite of the fact that he or she made the disclosure in good faith, and that's a magic word here, for the purpose of improving security. Okay? And letters like this are kind of the reason why it's now standard practice for software companies to reward people who voluntarily report security vulnerabilities. Okay, some of them give you money, some of them say thank you, bye-bye, and that's it. But the point is that most software companies have realized that there's real value in having all these people working on a volunteer basis for free to find these security vulnerabilities. Okay? But the problem is, and that's great and everything, and that seems to be the way things are going, but that's not a standard. They're not required to react that way. Okay? That's basically when you do this, you're at their graces. And unfortunately, people react like this. There's the people who pay you and thank you, and then on the other side, there's the people who freak out and call their lawyer. Okay? And there's nothing requiring one or stopping the other. So how do you protect yourself? This is the practical element to this. So ethical hacking is legal, which I guess that's what we're talking about here. We're talking about ethical hacking, as long as it's performed with the permission of the person whose system you are exposing the vulnerability for. Okay? Now, whether or not you're actually engaging in hacking is an important question here, and that's why we dealt with the criminal code provisions, because those are the provisions that would govern whether or not you're actually hacking in terms of criminal liability. Okay? And those definitions inform what your civil liability would be if you're hacking without somebody's permission. Now, many courses teach methods of ethical hacking, and many of these certifications, like CISSP, have like codes and policies. By my own admission, I haven't dug into them as much as I would have liked, so if I say anything wrong, I would like to be corrected immediately, possibly with a tomato. Please don't do that. So two interesting tidbits about CISSP. The first tidbit is completely unnecessary, and that's that green is a very calming color, and it denotes security, and that's probably why they've chosen this for their logo and the majority of their materials. But it also is a registered trademark, okay? And that means something. That's actually the power of that brand. Now, I guess the third interesting tidbit in that in Canada, the R doesn't actually mean anything, but American patent agents who practice or copyright agents and trademark agents who practice in Canada put that on there anyway, just in case, okay? But it doesn't actually do anything in Canada. What it means is that it's a brand, okay? So the Canadian trademark for CISSP was filed in 2003 by the International Information Systems Security Certification Consortium, Inc., which kind of makes them sound like their CEO looks like this. Okay, yeah, Star Trek, yay. But It was registered in relation to specific services, okay? And these services are the provision of, don't read that, the provision of information security by professionals, certified by ISC, and the development and implementation of strategies and policies related to information security, okay? That sounds like good stuff. That's fair. But this was registered, and this is where we really dig into the nitty-gritty of this. This was registered as a certification mark, okay? And a certification mark is a special kind of trademark. And in Canada, that means that it's connected basically with a set of rules that in order for anyone who wants to use that logo, in order for them to use it, they have to follow those set of rules. Okay? They're basically licensing that trademark term, that trademark logo, in order to basically give themselves authority, okay? So in order to have a certification mark, we've got character equality conditions, our class of persons, and a specific area that it's in. So it's a gatekeeping function, okay? That's what it is. All it is a certification mark is, in order for you to advertise yourself as CISSP, you need to have these, you need to be certified by us, then you're licensed by us, you need to comply with our policies, okay? But that's not really a shield. That's not a lot of protection for you, okay? CISP is a brand. It is not legislation, okay? And here's where I'm not bragging. I'm trying to use that as an example. Lawyers are a creature of legislation, okay? Lawyers have a legislated monopoly where we're the only ones who can practice law. And in exchange for that, we have a very specific set of rules that we have to follow, and those rules are codified in law, okay? That's a creature of legislation. And these rules are very clear, okay? And if you don't follow them, you're out, right? You get disbarred. But you guys don't have that. What you have is you have a certification mark. That doesn't mean you don't have any protection, because what the certification mark has done is it has allowed the development of an industry standard. I'm not talking just about CISSP, okay? I'm talking about the fact that your industry is gaining more of an identity. And as you gain an identity, you set up standard practices that you all agree, or maybe debate on the finer points of, but you set up general practices that you all agree are the best practices. Okay? And those things are powerful. Industry standards are what protect you, because in a negligence suit, the question really boils down to, did you comply with industry standards? If you did, it's less likely you're going to be found liable. If you didn't, then you're in real hot water. So what does this all mean? I'm going to try and round it up in some questions and a case study. So really quick, rapid fire. I'm an employee. I discovered and disclosed a vulnerability to a third party, not my employer. Can I be fired? The easy answer is yes. You can be fired for off-duty activity. So if you expose a vulnerability, okay, and that third-party company gets pissed off, they contact your employer, they can fire you. It's actually really hard to do. It is difficult to fire somebody for their off-duty activities, but if those activities are found to endanger the reputation of the company, then it's more likely that you could be fired. So next one, I'm an individual. I discovered and disclosed a vulnerability to a third party without permission. You actually found it without actually asking their permission. Can I be sued? And the answer is yes. And we have a new tort. It started in Ontario. It's since made its way to Nova Scotia. It's the tort of invasion of privacy. Okay? And basically, if you, and it doesn't only apply to computer systems, but if your conduct is intentional, okay, in accessing the information, if you invaded without lawful justification, right, we're going into that color of right element, the private affairs or concerns of somebody, and if a reasonable person would find that invasion highly offensive, then you could be found liable under this tort. Now, this tort is very limited, because obviously this could apply to all sorts of situations. It's limited to the personal information that a reasonable person would feel very violated if it were released. So financial information, sexual information, like private diaries that are, you know, a little bit more than, I love so-and-so, heart, 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 a little bit more than that. But the damages in this tort are quite real. They go up to a maximum of $20,000. Okay? And that's punitive damages. That's aside from the damages if somebody loses their job, then you have a wage loss claim. Okay? So the tort is actually quite serious. Now, I think it would be very difficult practically, and I searched and searched, and I couldn't find a single case that applies directly to what we're talking about here in Canada, but I think it would be very difficult for somebody to find a person who voluntarily disclosed a security vulnerability for liable of that sort. It would be difficult, but still, it's there, and the point is that we don't know. And when we don't know, we have to exercise extreme caution because the consequences can be very real. Okay? So another one, I'm self-employed, I discovered and disclosed a vulnerability to a third party, not my client, can I be sued? The answer is yes, just like before. You can either be sued individually, or if you have a company, your company can be sued. But if you're incorporated and you're practicing your trade under an incorporated entity, you can still be found liable for criminal activity personally, okay? So let's do a case study. I'm kind of running out of time, but I really want to talk about this. So, I know. So this is an actual, so I don't know, this person who's the subject of this case study may be in the audience today. This actually happened. So what occurred was my client was having a house built. He logged into the builder's online portal and noticed that he could view other customers' information just by changing the URL. Sounds familiar, right? So they basically accused him of hacking into their system and probably pictured him in a hoodie typing away in the dark or something like that. But so they requested the return of all of the information. Don't bother reading that, it's a lot of text. And all the downloaded material. And they also wanted proof to their satisfaction that he had removed all of the information from any other machine, okay? Which it's like, how do you do that? You prove a negative. It's really difficult. And they also barred this person from accessing their site, so they denied them the use of that service anymore. So I'm a professional. I know that I get a bit goofy at this conference, but I like to think that I conduct myself very professionally, like a real stuffy lawyer and everything. But when I get a letter like this, my reaction is like this, okay? Now, because we couldn't email this photo to the lawyer on the other side, we couldn't do that, we sent a letter, okay? And by the way, I should say that I have this person's consent to tell you about this, but I've kept their name private because there's no need to identify people unnecessarily. So don't read that letter because you might find a typo or two. So in this letter, we basically said, look, your website was inherently insecure. Okay, that's your fault. You had no security protocols preventing access between user accounts. So once somebody was logged in, they could go around and look at everybody. That my client accessed the information merely to confirm the vulnerability, so he suspected it, and then he accessed the information in order to confirm that the information was not his, okay? The client was an authorized user of the site, so there was no user term preventing him from changing the URL. That argument was a little bit crappy, but sometimes you throw these things in and you see how they go. And also the client felt an ethical obligation to probe that vulnerability, to figure out its extent, in order to fully disclose it to that person. So he was acting in good faith. Okay, we're using that word multiple times. And also, I also pointed out the irony of the situation in that if he couldn't, or if he hadn't disclosed it to you, then using his professional knowledge that he was now being punished for, then somebody else may have, with a nefarious purpose, may have used that exploit to gain access to intensely personal information. So private information, financial information, right? It's house building companies, so they would have information on income, they would have bank account information, they would have all sorts of information on family status, they would have all of that information because of the financing involved in building a house. So he was helping them, and they came down on him like a ton of bricks, or at least they thought they were. So we sent this letter off, and then in response, nothing. Okay? And part of that is because actually bringing these things forward. So in every legal issue, there's multiple stages. One of the stages is the lawyers posture at each other and kind of beat their chests and stuff. Use big words, very scary letterhead. But moving beyond that in these types of claims is actually really complicated. And it's not only complicated, it's incredibly expensive. And where there are very limited damages, it is almost never worth it. So although you get these letters, and please, I'm not going to say don't respond to them, because not responding is usually worse than the alternative. But usually they don't go that far as long as there are very limited damages and as long as the company can prove that they did their covering their ass exercise, okay, and kind of moved on. But the point remains that tort is available, okay, so the tort of invasion of privacy, and also any criminal liability that you may have is there. Okay? It's entirely possible that they could call the cops. It's entirely possible that they could start a lawsuit against you. And even if reports to the police are completely groundless, even if a lawsuit is completely frivolous, you still have to deal with it. Now, on a side note, these people gave no confirmation of whether or not that what they called a breach was disclosed to their patrons, so they're bad kids, we're pretty sure. So this bingo is my favorite thing. I found it on the internet. God bless the internet. So when you disclose a vulnerability that you've discovered off the clock, you are taking a significant risk. Because one of the items on this bingo are, look, we've called this to the police, cease and desist. Those are real things that happened, as we've talked about today. And maybe your insurance, if you have insurance, will protect you. But are you sure that you've complied with all of the industry standards? Are you sure that your insurance will cover you if you're off the clock? Many of you have insurance through your employers. Will your insurance cover you if you're off the clock? Do you really want to explain this to the police? Do you really want to explain this to your employer? Probably not. But the reality is that when you discover a vulnerability and you're off the clock, it's not your job to disclose it, and you don't have permission to be poking around in the first place. You're putting yourself at the mercy of the reaction of the person who owns the system. Completely at their mercy, okay? And without any solid protection, and at the mercy of multiple areas of law and legal principles that were created prior to the internet, okay? Because we're dealing mostly with old legal concepts, you're at significant risk. And many of these situations, we don't know how to handle them yet, right? Which leads me to my most succinct takeaway ever from any talk I've ever done. If you're good at something, never do it for free. Oops, there. Okay? All right, that's it. That's my time. Thank you, everybody.